Hey everybody, hope you're doing great today. This is Paul Cyan, Realtor with United Real Estate Home Connections. I'm licensed in the state of Ohio and Kentucky. And in today's video, I'm going to take you through the contract to purchase for the state of Ohio. So this contract is applicable to both the Dayton and Cincinnati area. It does not work in the Northern Kentucky area. Northern Kentucky has a different contract, and I will talk about that one in a later video. So with this video, I'm going to explain the different sections of the contract, kind of give some ideas of what you need to be putting in there. This video is great for both buyers and sellers. Both sides need to understand it. Now, this contract is primarily used for residential transactions, though I've seen it used in the past for commercial transactions. You can use it for commercial transactions. There's different terms in there that might not apply to commercial. There is a MLS contract for commercial real estate. It's a little smaller than this one, fewer pages. I personally use, if I'm writing a commercial real estate offer, I will use what's called a PSA. PSA standing for Purchase and Sales Agreement. So I will use that for commercial transactions, for purchasing commercial real estate. And usually that's much longer than this. The version I have is a Word document. It requires editing within there. As with any contract, if you don't understand anything, do talk with an attorney. I am a real estate agent. I am also an attorney. Nothing in this video is considered legal advice. Definitely speak with your own attorney. And as I mentioned, this is primarily for the Cincinnati area. The Dayton and Cincinnati boards of realtors have both adopted this. This contract was reviewed and approved by their own legal counsel. So let's take a look at the contract. So here's the contract. We're going to go through this contract one section at a time. So this version of the contract was updated in October 1st, 2021. Paragraph 1, property description. Basically, this is where you put in the address of the property. If you have information like the parcel number, it's helpful to add that in there. Number 2 talks about timelines. Basically, any timeline that you have in this contract, you need to pay attention to, you need to adhere to. Specifically, things like closing date, inspection date, response due from the seller for inspection repair requests, those type of dates. You miss any of those dates, you lose some rights in there, especially in case of the buyer. If the buyer does not schedule their home inspection in time, they will lose out on the right to have the seller make any repairs. And if the seller doesn't respond in time to the buyer's inspection request under this new contract, the seller is bound then to make the repairs that were requested by the buyer. Price and terms. Here's where you're going to input the price that you want to pay for the property, whatever that price is. Whatever you set in there obviously needs to go to the seller. The seller can decide, okay, I'll accept that price. No, I won't accept that price. They can counteroffer. If the seller does counteroffer, then that becomes a new offer. So let's say, for example, there's a $300,000 house. The buyer offers $290,000, sends it off to the seller. The seller says, no, I want $300,000. They cross off the $290,000. They put in $300,000. Once they do that, once they've counteroffered, that original offer of $290,000 is no longer on the table. So let's say the buyers say, okay, we're going to go look at another house. We're not going to worry about this one anymore. The seller can't come back and say, okay, I accept your $290,000 offer. They would have to go back to the buyers and say, okay, if you're willing to offer me that $290 again, I will accept it. But once that seller has crossed off that $290,000 and said, I want $300,000, they've in essence canceled that prior offer from the buyer, and then the buyer has to re-offer it if the seller wants to accept it later on. In addition to the price and terms, you also put in the earnest money. Now, earnest money is not a legal requirement, but it is a customary requirement. So in most situations, sellers are going to be expecting earnest money. So once the contract is accepted, the buyer is going to write a check either to the title company, which will hold it in their escrow account, or they can write it to one of the brokers who can hold it in their escrow account, and that money is held until closing. There are certain situations where a buyer can get that escrow money back. That depends on the facts and circumstances, and that's going to depend on if they're doing it within a proper time frame. So if they still were within their inspection period and they canceled due to some inspection issue, they have the ability to get that money back. It's not automatic though. The seller has to agree to give that money back. So let's say, for example, financing falls through. If the seller signs off on a mutual release that says, okay, we're ending this contract, the buyer also signed off as well, then usually that release will also dictate where that money is going to go. In most cases, the buyer wants that money back, whatever amount of money that might have been, $2,000 for example, that goes back to the buyer. Now, if the seller refuses to sign the release or is making a claim for the earnest money, then the money cannot be released. Basically, it sits in the broker's account or in the title company's escrow account, either until the buyer and the seller agree how the money is to be divided. They go to court and they get a court order that says, okay, the money is going to go to this person or that person. Or in the case of Ohio, if the buyer waits 2 years, they can go back to the title company or to the broker and say, hey, no court case was filed, so give me my money back. Here's a section for settlement charges. Basically, the buyer is asking the seller to pay closing costs, is a common example. So the buyer needs $5,000, $7,000, $3,000, whatever they need. They want the seller to contribute from their proceeds toward those closing costs, so that's less out of pocket for the buyers. In the case of a buyer's market, sellers are going to be more likely to be paying closing costs. In the case of a seller's market, where sellers have control, asking for closing costs could hurt the buyer's offer, especially in a competitive multiple offer situation where there's multiple offers. Buyers might not want to ask for closing costs unless they're going above the offering price to account for those closing costs. Section 4 over here is the financing contingency. Basically, if you are taking out a mortgage or some sort of loan in order to purchase this property, you want to make sure that these are checked properly, so that way if your funding, if your loan or whatever, it does get pulled for whatever reason, you're not still on the hook to purchase this property. In this case here, we have the sentence, buyer intends to use the real estate for the following purpose, either owner-occupied, rental, or other. In the case of owner-occupied, that means the buyer actually wants to live in the house, versus a rental, they're purchasing the property as a rental property. There is a difference between rental and owner-occupied, mainly in the terms of the down payment, something to discuss with your lender. Usually if you're buying as a owner-occupied, you qualify for different types of loans. You don't have to put as much down, versus with rental properties, your down payment increases because the bank wants to protect the loan. Now, if it's a cash purchase, you can check the cash box. Generally with either a mortgage or even with cash, the seller is going to want to see proof of funds for cash. Basically, you have the money in the account, you have it, you can get it from somewhere. Or with a mortgage, you're looking at a pre-approval letter that a lender has already looked at your credit initially and is agreeing to provide a loan for this amount of money to purchase this property. A couple different types of mortgage loans that you have. You have conventional loan, that's your typical, usually 5 to 20% down. Then you've got your other type of loans. You got FHA, USDA, VA. Some like the USDA and VA, buyers have the option to do a 0% down. With regards to FHA and VA loans, they usually have different requirements compared to a conventional loan. The appraiser can also do an inspection of sorts, and if there are any repair issues, safety issues, they will call those out, and those issues will need to be corrected prior to them approving the loan and allowing the buyer and the seller to close on that transaction. Other funding source, if you're using, say, a home equity line of credit, hard money loan, this would be the box to check for that. This is more applicable to somebody who's buying as an investment property versus buying an owner-occupied using a mortgage. So you've got your paragraphs A, B, C, and D over here. Basically, A is saying, here's a pre-approval letter, or I will provide a pre-approval letter, and the pre-approval letter either is contingent on me selling a current house that I have if I'm the buyer, or it's not. Basically, I have enough funds I can buy the house without selling my current house, or I don't own a current house, I'm renting, and it's just a matter of me purchasing a new house. Generally, sellers are going to want that pre-approval letter pretty quick, so if a buyer is going to provide it, if they don't have it right away, try and get it within a day or two at best. Usually these sellers are going to be hesitant to accept an offer until they see that pre-approval letter. So with B, C, and D, those are basically time frames related to the mortgage. With regards to B, that states once the offers have been accepted, you're going to tell the lender, yeah, go ahead, proceed with the application. I want to apply for that loan. C and D are timelines that are generally obtained from the mortgage lender. They'll tell you when they're able to provide things like a conditional approval and when they'll give clear to close. So for filling out C and D, you should talk to your mortgage lender. Paragraph 5 over here, appraisal contingency. Basically, if you're buying with a mortgage, depending on the amount down, you will be required to have an appraisal on the property to make sure that the value supports the purchase price. If you're purchasing with cash, then an appraisal becomes optional, and there's a fill-in for that. If you don't want an appraisal with a cash offer, that is your choice. Paragraph 6 over here covers inclusion, exclusion in the sale. What's coming with the property, what's excluded with the property. So usually things like fixtures, Things that are attached to the house, they generally come with the property. For whatever reason, the seller may want to exclude certain things. For example, let's say you have a chandelier that's a family heirloom. Even though it's affixed to the property, the seller is like, I'm taking it with me, and they need to note it in here. This paragraph also includes a list of things that are considered fixtures that need to stay. Things like blinds, storm doors, window doors, shrubbery, landscaping, affixed humidifiers, water softeners, water purifiers, central vacuum systems, smart doorbells, garage door openers. So basically things that are fixed and attached to the house need to stay with the house. And also things that are in the house right now. Let's say a house has a particular fixture, particular brand of fixture. It's a premium brand. When the buyers move in, if that premium brand isn't there, if the sellers happen to go take out the old fixtures and put in these old cheap ones, there could be problems there. 6A is where the buyer can add, okay, I want the trampoline in the backyard, or I want the hot tub. 6B, the seller can write in items that they aren't planning on leaving. Like I mentioned, with the heirloom chandelier that's affixed, they can take that off, and either they can leave it open, not put anything in there, or they can agree to put something equal, or give the option to the buyer of, you pick something and then feel free to put it in when you move in. It's a negotiating point, it's an agreement point. The buyer and the seller need to discuss with each other and get that in writing. If it's not in writing, then it's generally not enforceable. Things like your refrigerator, your oven, a microwave, they're considered to be part of the house. Things like a countertop microwave, that's more of a personal item, so the seller is able to take that with them, that now they can agree with the buyer, they can leave it if the buyer wants it. Similar also with washer and dryer. Usually washer and dryers don't stay unless they're written in the contract. Sometimes sellers will want to leave them because they're moving out of state. They don't want to carry that with them. They want to buy something new, so they'll leave it. But if it's not written in the contract, don't expect it to be there unless it's a fixture, unless it's something that's built in. Paragraph 7, certification of ownership. Basically that says that the seller owns the property, their name is on the title. Any liens, any mortgages, anything else, any encumbrances associated with the property will be cleared upon closing. Generally that's taken care of by the title company. They perform a title search. They go through the process, make sure there's no liens, all mortgages are paid off. So once the buyer takes ownership of the property, they don't have to worry about that. Paragraph 8 is seller certifications. This basically relates to conditions of the property. Is it a historic district? Is there a tenant in there who's leasing the property? Is it located in a floodplain that needs flood insurance? Are there any encroachments? Is there any property tax abatements? There's a number of items in here. So this is something really that the seller needs to provide input on. The way I've seen it done before, especially in a fast-moving market where buyers are moving quick, the real estate agent will fill it out to the best of their knowledge, send it over to the seller, and then upon that point in time, the seller realizes there's a mistake over here. It should be, it is in a historic district, whereas the buyer's agent wrote it's not. They would go and correct that. That way the buyer knows when it comes back to them. There's some difference there than how it was originally filled out. Section 9, homeowners association, condo declarations, bylaws. Do you have an HOA basically? If you have an HOA, you need to state that there and also provide what are the monthly dues, the annual dues, and what does it cover. In terms of what does it cover, by providing a copy of any HOA docs to the buyer, the seller is fulfilling their obligation. Then it becomes the buyer's responsibility to review those HOA docs to understand how much they have to pay and what is covered. Number 10 covers maintenance, and basically with regards to the maintenance, the seller is supposed to keep it in current condition, the way it looks right now when the buyer walks through after home inspection. It needs to be maintained properly, so that way when the buyer does close, get ready to move in, they're not getting into a house that's substantially worse off than when they first saw it. There is a fill in there that can be optionally filled in by the seller. Basically states that the seller is going to repair everything in the house, keep it in a normal operating condition except for whatever you want to fill in there. The reason for filling that in might be because something's is bad, something is not working well, and for example, there's a hot tub there, it's not working well, you're not going to maintain it, you're not going to repair it. It's not essential to the house like the furnace is or hot water heater is, so you're not agreeing to do any more updates or maintenance on that. Number 11, home warranty program. Basically, are you wanting to purchase a home warranty? Does the buyer want one? Who's going to pay for it? Is the seller going to pay for it? Which home warranty company? And if you want the seller to pay for it, you need to write that in there that the seller will pay for it, and an amount not to exceed XYZ dollars, however many dollars that warranty costs, that the seller won't have to pay more than that. Property disclosure form, that's an important form here in Ohio. Seller needs to provide a property disclosure form that states the condition of the property. There are different ways of filling that out. I'll cover that in a separate video. But in this paragraph, the buyer is acknowledging have they received it or not. If they haven't received it, it gives them another loophole to get out of the contract. So it's always advisable for the seller to fill that out, make sure that the buyer gets it. Buyer's off-site acknowledgement. This basically covers things like zoning, the school district, crime statistics, sex offender registration, noise level, like you live next to an airport, next to the freeway, other things like environmental. Basically, the buyer is responsible for all those items. It's not the responsibility of the seller. The seller can disclose certain things based on the property disclosure form, but there are other things external to the seller that the buyer needs to conduct their own due diligence and make sure they understand the condition outside of the property. Number 14 is an important section, the real estate inspection contingency. Basically, this is the home inspection section. This is where you're going to put in the time frames for inspection. This is where you're going to put in the time frames that the seller has to respond to repair requests. Discusses over here whether the buyer has received a lead paint disclosure. Lead paint disclosure is going to be needed for properties that are built 1978 or earlier. There are a couple options here when it comes to home inspection. The buyer can waive the right to a home inspection. They can ask for a limited home inspection where they're only looking at things like termites, lead paint, or something else, or they can request the right to perform a full inspection. I do not recommend any buyers waiving the right to inspection. By requesting a full inspection, you need to set in how many calendar days you need for inspection, especially during a busy time of year, like springtime. Inspectors can be very busy, so you might need a little extra time, versus in your downtimes, inspectors are ready to get to a property within a couple of days. So that's something you need to account for too when filling this section out. Paragraph B here in this inspection section, basically, once the inspection is done, you've got a repair request list. How many days does the seller have to respond to that repair request? You should give the seller enough time to respond. You might need to extend some of these dates, especially if the seller wants to bring out a contractor to reevaluate something that the home inspector said was an issue. They don't believe is an issue. The home inspector is more of a generalist. They're going to tell you, okay, I see a potential issue with the furnace. Contact an HVAC technician, have them evaluate it. So the seller can counteroffer the buyer's repair request. They can either agree to do nothing, they can agree to do all the repairs, or they can do something in between. Rather than do repairs, they'll give you X dollars so the buyer can do their own repairs. Or they might say, I'm not going to do repair on this thing, but I'll repair these other two things because I don't think this thing is bad. So again, that becomes a negotiating point between the buyer and the seller. So generally in this contract, the buyer cannot use the home inspection period to walk away from the property, even if there's something minor in there. The contract does allow the buyer to walk away without providing a repair request if there's something major in there. And they cover these major issues in here. So for example, structural integrity of the building, presence of asbestos, presence of lead paint. And there's this other section in there. If the buyer knows they do not want to deal with XYZ, they can put that in there that even if this issue is in there, then they can use that as a reason to cancel the contract. I mentioned the hazardous materials can be things like toxic substances and other hazardous materials that are classified that way under federal, state, or local law. Includes things like asbestos, formaldehyde foam, things like mold as well too can be considered hazardous depending on the level of mold. So as always, if there is a question, there is an issue, talk to your agent, and then you might even need to bring in an attorney as well too. Property survey, under this paragraph, the buyer is responsible for making sure that the boundary lines of the property are the boundary lines that they're supposed to be. The seller may have information on that, but that's always subject to change. It's still the buyer's responsibility to make sure that the property's boundary lines are what they say they are. Sometimes the lender will require a survey to be performed if there's questions as to the boundary lines of the property. Property insurance verification contingency, basically the buyer is responsible for making sure the property can be insured. The buyer has 14 days to confirm that they can get insurance. If they can't get insurance, then they can use that as a reason to cancel the purchase of the property. The one thing to consider though, even though there's 14 days here, if a buyer cannot get insurance on the property and they are also applying for a mortgage to purchase the property, the lender is going to deny that loan, and that's another way that the buyer can cancel the contract. Seller's cooperation. Seller agrees to make the real estate available, reasonable hours, to be accessed by the buyer, the real estate agents for the buyer, the inspector, any appraisers, and anybody else who's authorized to be there to help move this transaction forward. Section 18, you can put in any other items in there that you need to request. If you're requesting a specific thing to be done, or there's something that your lender wants you to put in there, that can be entered in Section 18. Something to discuss with your real estate agent and to discuss with your attorney if need be. Title insurance is something to protect the owner of the property. It basically covers from losses caused by defects in the title, defects in the chain of ownership, chain of custody. So if there was somebody prior to the current owner who claims that they own it, they could always come in there and say, hey, this was sold from me illegally, it's my property, give it back to me. Title insurance will step in and protect the current owner at that point in time. If there's any hidden liens or any hidden mortgages that the title company didn't find, then the title insurance will also protect in that situation too. Title insurance is optional. If a buyer is buying the property with a mortgage, the mortgage company will require title insurance just for the amount of the loan that they're providing on the home. The buyer can pay some additional money to get the title insurance to cover their own interest in the property. So especially if they put down 20% down as they're building equity up, their own value is going up in that property, their own equity value. So you want to protect that. It's a one-time fee, it's paid upon closing, and in this case too, the buyer can ask that the seller pay for it, the buyer can pay for it, or they can say no, they don't want it. Section 20, prorations, real estate taxes and assessment. This covers how proration is going to be done. So generally this covers how taxes are going to be prorated. In most cases, the way it's specified in there is the way the proration is going to be done. If you have any questions, I would recommend talking to the title company and asking them about the proration, this short proration method. Usually it's not used, but there may be different situations that it may be applicable to you. Feel free to talk to the title company. This section does cover assessments. Any special assessments, they need to be listed in there. That way the buyer knows any additional tax bills that are becoming due when they close. This also does refer to new construction. In the case of a new construction, that the property may not be registered just yet because it's a new home. It's not in the tax officials' records, so upon closing that will get registered, so the numbers might change. There may be other prorations to cover in here. So for example, HOA dues, if the property is rented out, splitting any prorated rent, so tenants are paying on the first of the month, they're closing in the middle of the month, how is that prorated? Any security deposits, how are they going to be credited to the buyer? Conveyance and closing, this is where you're going to enter the name of the title company who's going to be performing the closing services, the date of closing, as well as if you want to put it in the name of the deed, who's getting the deed. For example, if you're purchasing in cash, you want the deed to go in an LLC versus your own personal name. That could go in this section over here too. Possession and occupancy. This determines when the buyer will get occupancy. So it's not always the case that upon closing the buyer gets both possession and occupancy. Possession means they own it. Occupancy means they get to live in it. Sometimes they negotiate with the seller. The seller might need a couple of weeks after closing to move all their stuff out. Or if the case there are tenants in there, then technically the buyer cannot have occupancy because there's tenants in there under an existing lease. So those need to be discussed beforehand. If it's usually a typical buyer and a seller, the buyer can ask that closing and occupancy be done on the same date. The day of closing, buyer gets the keys, they get to move in, and the seller has already been moved out by then. Agency disclosures refer to state mandated disclosure forms that I as an agent have to present to my clients, and the sellers or the buyer's other side, basically the other side's agent has to present to their clients. Company specific provisions, and it depends on the situation, what's being done. If it's being purchased by a corporation, investment company, do they need to put in anything in there? Paragraph 26, MLS and public record and acknowledgement. Basically, the realtor is going to record the transaction in the MLS, and the buyer and the seller agree to that. Number 27, the sold contract. Basically, everything in the contract is what the contract is. Nothing oral, nothing agreed to on the side, nothing agreed to in a separate document is part of this contract. Paragraph 28, general terms. All the language in this contract, the transaction is governed under the laws of the state of Ohio. This is an Ohio contract. Anything that the seller certifies, represents, or warranties is good basically for a date of 1 year after the closing date. If there is a part of the contract that's found unenforceable, the remainder of the contract remains in effect. Paragraph 29 relates to tax matters and whether the buyer or the seller is a foreign person. There's some different rules and reporting requirements involved. Paragraph 30, electronic signatures, basically states that electronic signatures on this contract are valid. You don't just need pen and ink signatures. Paragraph 31, indemnity. The seller and the buyer recognize that there are realtors involved in this transaction, and they're agreeing to indemnify and hold harmless the realtors for any claims, demands, damages. So they're basically agreeing to indemnify and hold harmless the realtors, their agents, employees from any claims, demands, damages, lawsuits, liabilities, costs, and expenses arising out if the buyer makes something up or the seller makes something up. So basically, if it's settled between the seller and the buyer, the real estate agents will be held harmless under this clause. Paragraph 32, electronic and wire fraud. There are fraudulent attempts to divert money that needs to be wired for earnest money, money that needs to be wired for closing. So basically be careful, talk to your title company, talk to your agent, confirm prior to doing any wiring to lower the risk of fraud. Paragraph 33 basically says if you have any questions about the contract, talk to your attorney. Paragraph 34, contract acceptance date, basically states the contract acceptance date shall be defined as the date on which all provisions of the contract have been accepted and agreed to by all parties of the contract. So usually it's going to be by the last day. So buyer signs today, seller gets around to signing tomorrow. Assuming the offer hasn't expired, then tomorrow would be treated as the contract acceptance date. Expiration. Generally, all of these offers have an expiration clause, and in that you're just going to write, offers hasn't been accepted yet, but my offer is $300,000 for this property. You need to accept it by 10 p.m. tonight, or you need to accept it by 10 a.m. tomorrow. However much time you want to put in there, you can put that in there. That way it's not sitting out there for forever, basically allowing the seller to accept at any time. Buyer certification, this is where the buyer is signing off saying, yes, this is our offer, and we understood and read all the terms in the contract here. Action certification by the seller. Under this paragraph, the seller can choose to accept the offer as is. They can reject the offer, which in a lot of cases, sellers don't even reject the offer. Here, they'll either communicate that via email, via their agent, or they can ignore the offer, wait until it expires. That's considered a rejection. Or if they want, they can counteroffer. So in terms of counteroffering, as I mentioned before, counteroffer is treating the old offer as void, invalid. So it's basically a new offer from the seller to the buyer. The rest of the section down here below, this relates more to the earnest money, the realtors, the real estate agents confirming they received the earnest money, and this other is fill-in for the title company. If you were able to watch this video the entire time through, you deserve a prize. It was a long and dry topic, basically going over the contract terms. And just to note, I didn't go into a super deep dive into each of the paragraphs of the contract. There is a lot of different nuances in the paragraphs. And if you do have questions, if you are working with a real estate agent, by all means talk to that real estate agent. If they're not able to get you the answer that you need, speak with an attorney. Having an attorney on your side during the process of buying and selling a home is helpful, and they can guide you on the legalese that's found in this contract and help you understand and make sure that you select the best options for you. If you're not working with a real estate agent and you're in the greater Cincinnati or Northern Kentucky area, feel free to reach out to me. My contact information is in the description section below. I'd be happy to help you out. Happy to help you buying a home, selling a home, investing in real estate. As a real estate agent and an attorney, I do have a little better understanding of the language in these contracts. So if you could, please hit that like button. Please subscribe to the channel. Thank you for watching, and I will see you in the next video.